Hello guys, and welcome to another episode of my lecture. On today's episode, I will be talking about section 11 of the Evidence Act, facts showing existence of state of mind, body or bodily feeling. In my last class, I talked about section 10, basically on facts relevant when damages are claimed, and I cited two authorities for that. The case of Donohue versus Stevenson and the case of Carper and De Alberto versus Aquintilo. In this class, we basically talk about section 11. Now, section 11 tells us that facts showing the existence of any state of mind, such as an intention, knowledge, good faith, negligence, rashness, ill will, or goodwill, particularly towards any particular person, or any state of body or bodily feeling, are relevant when the existence of any such state of mind or body or bodily feeling is an issue or relevant. See, a fact relevant as showing the existence of a relevant state of mind must show that this state of mind exists not generally but in reference to the particular matter in question. Now, to explain this, the provision of this section clearly, with respect, show that the decision of the Court of Appeal in the case of AWAYE Motors Co. Limited versus ADEWUNMI 1993 judgment to the fact that only an expert can give opinion evidence is par incuriam, or at least too sweeping, as nothing in this section suggests that only an expert can give evidence or opinion on the states of mind or body with matters listed in this section. Such opinion from clear wordings of section 1 and 2 of the section must not be general but limited to the fact in issue or relevant fact in the trial. In the case of Samuel versus COP, appellant was issued with books of notes ticket for sale to public at a race meeting and was proved he had reserved some ticket from the bottom of books. The court allowed evidence proving he had done previous thing. It was held relevant and admissible. In the case of R versus GRILICPOULAS, the accused was charged with receiving stolen thing from P. Evidence given showed they had received stolen thing from other people on same day and earlier that week. The court held that those other instances were admissible, as other instances could show that receiving was accompanied by guilty knowledge that the thing was stolen. Now, this section, to understand it better, is what I call the mens rea section. You see, everything that I've been teaching you since is basically like actus reus. They show you the acts in itself. Do you understand? You prove the acts. Do you understand? However, this section is what I call the mens rea, where you can, to a particular extent, prove the intention. Do you understand? So now, let us look at the first case, the case of R versus COP, where somebody was given certain ticket at a race meeting. Now, instead of him to sell those tickets, he decided to take from the bottom of those tickets and kept it in his pocket. Now, that can be regarded as fraudulent. Do you understand that? He can help us prove his state of mind. That as at the time when you took away those tickets and put it in your pocket, what was your intention? To a reasonable person, that would amount to you trying to steal the tickets. Don't lie. Say the truth. Do you understand? And also in this case, where somebody received stolen goods. Now, for example, I'm sitting in my house and somebody just came inside. I said, Dieko, take, I'm coming now. Okay, I put it, and then police came to arrest me. And I'm like, police, I don't know what he's talking about. He just entered my house and he said, take, I'm coming soon. And then the police then decide to tender certain evidence that this person has not done it for the first time. The person has done it subsequent time, and each of those subsequent times, I knew that they were stolen. Now, it then proves, although I am not in trial for those subsequent times, I'm in trial for this one, but the admissibility of the evidence of those other times would be used to prove my guilty mind in receiving the stolen good this time around. Do you understand that? So, yes, they can prove that I received in other ones, and they can prove the guilty mind in other ones. but they cannot prove the guilty mind in this one, so they are relying on other ones to show the court that, my lord, you see this one, the fact that I collected it, he knew. Unlike if I had not collected at all before, he just came into my house and then bam, he dropped it. Do you understand? This is one of the reasons they tell you that if you want to buy a phone, go to the market and buy the phone. Collect a receipt. Don't buy a phone from somebody who say, hey, my guy, how far now? I get one phone, oh, how much? You know fully well that it is iPhone 13, and iPhone 13 will cost nothing less than 700 to a million as at December 2021. But instead of you to buy it at that kind of rate, you decided to buy it at 50,000 to 100,000. Because you're saying, oh yeah, I don't hit jackpot. It's time to kill them. I'll flex this December. And then police arrest you. And then you are now saying, I bought it from him. There is no proof that you bought it. If you had gone to a marketplace, then yes, okay, we can say yes, there is a receipt. If you had gone to an overt place to buy it, an overt marketplace where they sell phones standardly, and you can prove that was where you bought it, then everybody would know that you are not involved in this. But this is a color business. How do you prove it? How do you prove it in court? Do you understand that? So when you are talking about section 11 of the Evidence Act, section 11 talks about how to prove bodily feeling or your state of mind. Now, there used to be a saying that it is only an expert that can prove the state of mind. And then it is my submission that section 11 has done away with the case of AWAYE motors and ADEWUNMI, and it is not only experts that can prove. However, when I'm talking about expert opinion in my law of evidence 2, I would dissect what I mean there. But as at now, you don't need to worry yourself about expert opinion. What you need to understand is that we are talking about proving state of mind, body or bodily feeling. But do note that this is restricted to the fact in issue. So the fact in issue is that he murdered somebody intentionally. A neighbor who is outside can say, yes, I saw him. When he went outside, he was fidgeting. He was carrying his hand like this, and he was going up and down. He was doing this, he was doing that. Although I did not see him kill her, but this is what I saw immediately after I heard the gunshot. Now, that is a state of mind. What was your state of mind at that time? He was afraid, he was scared. That is a fact before the court. You can prove that fact through section 11 of the Evidence Act. That is what I'm saying. Do you understand that? So section 11 helps us prove a state of mind. It helps us tell the court this is what has been likely to happen. Okay, let us use the Miriam Sanders case, for example. Now, one of the reasons Miriam Sanders was convicted was because, according to the fact of the case, Miriam Sanders, Ibrahim Muhammad, the friend of Biliaminu Bello, the murdered person in this case, this Miriam Sanders case, he said that before he left the house, of which 1 hour after he left, he heard that Biliaminu was dead and he has been rushed to the hospital. Before he left the house, he collected knife from Miriam Sanders' hands 4 times. That is section 11 mens rea facts. That is a fact that you admit through section 11. The fact that he collected knife from her hands 4 times, it shows a state of mind that she's angry. It shows a state of mind that she's vengeful. It shows a state of mind that she can do anything at that point. And with that, after you've admitted that, there is a conclusion that can be drawn that yes, she killed the husband because it lasted less than 1 hour. Our excuse afterwards was that no, there was a scuffle between the both of them, and during the scuffle, they hit the shisha bottle broke on the floor, and mistakenly, because the baby was crying, she pushed him off her and went to meet her baby. Unknown to her, as he fell on the broken shisha bottle. That was the explanation before the court. Even you and I know that the blind or the deaf or the stupid can know that that's a lie. Especially when, number one, she had found naked pictures on his phone, to which she was very, very angry. This proves motive. Motive is section 6. It helps us torchlight what has happened. Although it is not an element to be proven in the case, but admitting the fact that Miriam Sanders had seen naked pictures on the husband's phone and she was angry when she saw it proves motive. You admit that through section 6. Ibrahim Mohammed has come to tell us that he removed knife from her hands 4 times. Now that proves what? That proves state of mind. It tells us that she is out to cause grievous bodily harm. It's an intentional thing. It is not reckless. It is not negligent. She intentionally went with a knife 4 times to meet him, of which Ibrahim Mohammed had to remove the knife from her hands 4 times. That's section 11 fact. Do you understand that? So with that, you understand how to admit evidence in court. You have to know how each of those sections, each of those relevant facts, how they interplay. And our 2 authorities for this will be Samuel versus COP and versus GRILICPOULAS. And with that, I end my class on facts relating to states of mind, body, and bodily feeling. And I hope that you get a grasp of it already. In my next and final class on relevant facts, evidence, we are going to be talking about section 13 of the Evidence Act. And what does section 13 of the Evidence Act talks about? It talks about evidence of course of business when relevant. I'll see you in my next class.